25 seconds of original time left. Do you intend to exceed that?
Yes, indeed, Madam.
Okay, so that I'll grant you the extended 15 minutes. Thank you.
Thank you very much, Madam Speaker. Madam Speaker, before we took the break, I was reading for the benefit of the citizens of the Republic, if not my friends in this chamber, the amendment that we propose in Clause 3, which is an amendment to Section 4 of the existing Act. And I had gotten to the point of subsection 4.2, new subsection 4.2, which says, nothing in subsection 1 shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, just pause, including, of course, and most importantly, magistrates' court, including appeals, applications for judicial review, and applications for redress under Section 14 of the Constitution, which we are all familiar with, that persons' rights have been infringed in a manner that is not conducive to the observation of the democratic rights and freedoms in this law-abiding society as it's supposed to be. We propose in Clause 4 as well, Madam Speaker, an amendment to Section 5 of the Act. And colleagues have that Act, but we are repealing subsection 1 altogether, a minor change to the side note, but we are, Madam Speaker, in the main saying in the new 5.1, any person may maintain an action against a magistrate for any act done in a matter not within his jurisdiction. So this contemplates that he acts outside of his jurisdiction where it is alleged. So in addition to him or her acting outside of the jurisdiction, the allegation must be alleged and proved that the act was done maliciously and without reasonable and probable cause. So there are those two elements that are necessary. So just to hark back very briefly before I close, the member for Chaguanas West described that possibility as a sword that the Attorney General was holding over judges in this country and made a song and dance over it. If that is the sword, it is necessary in any tribunal, any judge, any magistrate who acts outside of jurisdiction and does so, and you can prove malice and misfeasance in their conduct, in which case you should have a sword, because that cannot be acceptable in a democratic society, constitutional democracy, as indeed we are. In conclusion, Madam Speaker, I want the citizens of the Republic to know that this issue of the unfair treatment that is possible for magistrates vis-a-vis judges, in other words, and put differently, the protection that judges and the immunities that judges enjoy, magistrates do not now enjoy it. We now are moving to fix that. We respect the work of the magistrate. We respect the load that they carry in this society, the importance of their work. And based on the Jagru case and our general knowledge and experience, they deserve to be treated equally to judges in this regard. This, Madam Speaker, is not unique to Trinidad and Tobago. This has been achieved in many other jurisdictions a long time past. For example, in England and Wales, their Courts Act of 2003 at Section 32 says, and I quote, an action lies against a justice of the peace in respect, i.e. magistrate, in respect of what he does or omits to do, A, in the purported execution of his duty as a justice of the peace. So in the course of his duty, you still have an action, but in relation to a matter not within his jurisdiction. So he must be seen to act outside of his jurisdiction if, but only if, it is proved that he acted in bad faith. So in this case, in the Courts Act of 2003, Section 32, out of England and Wales, they require to bring an action against a magistrate. He must have acted outside of his jurisdiction. And in addition to that, it must be proved And you could only bring the action. So in other words, even if he or she acted outside of their jurisdiction, an action shall not lie against them. You must, in addition to finding that they acted outside of jurisdiction, you must as well demonstrate. And this says, and I quote, if, but only if, it is proved that he or she acted in bad faith. So, that's England. In Bermuda, the Magistrates Act of 1948, Section 10A, 1, says, a magistrate shall be immune from personal civil liability in respect of his judicial acts, whether within or without his jurisdiction. Whether within or without his jurisdiction. I have already gone through the amendments. I have already gone through the amendments as we proposed them, and I'm suggesting, Madam Speaker, that we stand here in full support of the measures offered by the Honorable Attorney General. And this will allow the magistrates to operate as they are doing, but now without fear of being subjected to litigation as are contained in the amendments proposed in this bill. I thank you, Madam Speaker.
I thank you, Madam Speaker. Thank you, Madam Speaker. I sincerely thank all honourable members for their kind contribution. I am very pleased to bring conclusion to this debate, Madam Speaker. I know many of my colleagues have duties in other parts of the country. I know my colleague from Oropouche East has torn commitments that he would like to attend to as much as us all. Madam Speaker, I'd like to thank the honourable members, in particular the honourable member for Laventille West, for practically winding up this debate. I think he traversed all of the issues by way of response. I just simply like to say to the one issue that I think is left apart from that which Laventille West mentioned, and that is the issue of why only this approach? Why not take the approach further as per the recommendation of Chaguanas West, who I compliment on a well-researched debate. I think Chaguanas West brought a great deal of contribution to the floor today. I'd like to say the government has taken note of, in particular, the New Zealand Law Commission in its fulminations relative to the extent of immunity, the personalities for immunity, and whether there ought to be parity in immunity between the superior and inferior courts of record.
The tea break is over. We are back in the chamber. It seems some of us tend to forget the decorum that is required. Attorney General.
Thank you, Madam Speaker. And in looking at the New Zealand Law Commission report, as well as the Commonwealth Magistrates and Judges Association's report, which is entitled The Status of Magistrates in the Commonwealth, it's a CMJA report of February 2013, we note that many jurisdictions have been struggling with the issue of whether courts of inferior record ought to have the same management between the other distribution of courts, that is, courts of superior record. It is true to say, Madam Speaker, that the limitations that are placed on the Magistrates Protection Act are going to be significantly removed by this legislation. I'd like to say in very summary fashion that whilst I welcome the member for St. Augustine and Chaguanas West in their contributions today, it is not true to say that Jagru was the first case concerning magisterial indemnity. There were several other cases that had arisen, but which weren't determined in the fashion that Jagru was. And therefore, the issue was well known. In particular, and I pay no blame to the honourable members opposite now, I put this blame at the feet of the previous Attorney General, Mr. Ram Logan. He sat on this issue 2011, 2012, 2013, 2014, into the final days of his term. And I think he did his colleagues a disservice in not bringing forward the issue, which I'm sure they would have agreed to treat with had it been centralized. Madam Speaker, Chaguanas West, in his absence, I was paying tribute to his contribution and the extent of research and to the very valid point that he had brought. I'd just like to say that in looking at New Zealand Law Commission report, looking at the status of magistrates in the Commonwealth report, we've not decided at this opportunity to to go further than we do because we're in the middle of conducting research by way of a law reform exercise to all of the other courts. We want to look at the Equal Opportunities Tribunal. We want to look at the Commission. We want to look at the Industrial Court. We want to look, and it's not as simple as saying, well, courts of superior record enjoy X. There is, in fact, a degree of dissonance between the respective tribunals, particularly when we look to the quasi-judicial tribunals that we've now brought into law with the land tribunal and the adjudication systems. And that's really just a quite simple reason as to why we're bringing this. That becomes very relevant when we look at the Summary Courts Act, Section 3A, where the qualification requirements for a magistrate are barely at 5 years practiced at the bar. So there is a need for positions. Trinidad is very unique. We have the Mirage phenomenon. The Privy Council's decision in Mirage number 2 allows for a Section 14 of the Constitution approach for challenge to a presiding officer in circumstances that other jurisdictions don't recognize. And I want to point that out in the New Zealand Law Commission's report, where they specifically asked themselves in their draft report whether the view should be that a remedy against the Crown as exists in Trinidad and Tobago, and they quoted Mirage number 2, which was relied upon in their Court of Appeal in the Begant case, should apply there. And as far away in the Commonwealth as New Zealand, a full exercise on limits of judicial immunity, state of mind, the significant good faith or bad faith, malice or knowledge arguments, the subject matter of immunity, the area of jurisdiction, the indemnity provisions, they were studied in detail, and importantly, they rejected the Mirage remedy, as they call it in New Zealand. They found it infra dig in their Commonwealth context to allow a judicial officer to be brought to court to have his or her credibility tested under cross-examination. And therefore, Trinidad and Tobago stands very unique, not only in our 1976 Republican Constitution, with the degrees and levels of entrenchment which we have, but very much so in the Privy Council having upheld in Mirage number 2, as it had, that Section 14 breach of fundamental rights provision, which prevails quite uniquely in our jurisdiction. So respectfully to the member for Chaguanas West, very good contribution, very good point. The rationale for not going as far as that just yet is that the work is being done by way of analysis. We give the undertaking to come back to the issue. I think this House can be well satisfied that I have given undertakings on the record on umpteen occasions, and on umpteen occasions I have returned to the Parliament to keep that undertaking. Madam Speaker, there is not much else to say. With respect to St. Augustine, the issues of malice have been well traversed, as has reasonable cause, etc. The case law is replete with an understanding as to that, and I think the member for Laventille West has properly traversed that, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603.
Attorney General.
Madam Speaker, in accordance with Standing Order 68.1, I beg to move that the Magistrates Protection Amendment Bill 2018 be committed to the Committee of the Whole.
Honourable members, the question is that the Magistrates Protection Amendment Bill 2018 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause.
Clause 1.
Madam Speaker, may I just inquire before you do it, insofar as the member for Point-a-Pay is sitting opposite me? I have not seen any circulated amendments, nor does the government intend to put certain things forward. Would it be agreeable that we actually were to treat with this in the round?
So can we do 1 to 3 then?
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stand part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill.
Chair, to the Attorney General, we'd like to recommend an amendment in clause 4 by deleting the existing clause 4 and amending it where in any claim brought against a magistrate in the execution of his duties, any order is made for damages or costs, such order shall be met out of the consolidated fund.
Madam Chair, could the member repeat that, please?
Is this would this be to section 5(1) or
Well,
section 5(2)?
well, it's clause 4, we're proposing to delete the amended clause that the Attorney General
In clause 4, there's A and B.
Yeah, the entire.
So
A and
the
B,
entirety,
yeah.
that's the proposal,
And
yes.
change it to these words.
Change which, please, with?
Clause 4, section 5 of the Act is amended by adding the following.
Adding to where, may I ask? Section 5 of
Section
the Act
5,
is
yeah.
1, a subsection 1, and a subsection 2. So your
Subsection
proposal relates
1.
to subsection 1, yes.
When any claim brought against a magistrate in the execution of his duties, any order is made for damages or costs, such order shall be met out of the consolidated fund.
Attorney General.
Madam Chair, I understand what my colleague is recommending. It is the let's take it the whole hog approach, if I could be permitted to use that expression, which is the argument raised by Shogunas West. I indicated that the government is in the course of looking at the issue of indemnity in its whole sense across the board. If we were to accept that language, we'd be buying that argument now. And as referred to in the debate without reviving it, we're not yet respectfully in a position to do that. So I must, in the circumstances, respectfully decline the invitation to accept that recommendation, but we are looking at it.
Yes, sir.
For clarity, is there something for magistrate or even the judiciary, something called indemnity insurances for?
No, this, may I?
Yes, please, Attorney General.
Thank you. I appreciate the member's question. The state self-insures, if I could use that expression again. So it is not economical, nor prudent, nor customary that the state insures. In fact, there are examples where lenders require us to insure. It results in hundreds of millions of dollars spent where we could have, had we self-insured, spent much less. So it's not something that we do, and it's not in the interest of the state to do that because the state is too large an entity. And then who's underwriting it would also depend upon risk, and risk in the context of the current situation would be almost impossible to factor, and the cost would be astronomically high.
The question is that clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill. Honorable members, the question is that the bill be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. Attorney General.
Madam Speaker, I wish to report that the Magistrates Protection Amendment Bill 2018 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that the House agree with the committee's report on the Magistrate Protection Amendment Bill 2018. All in favour say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be forthwith read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be forthwith read a third time and passed. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I am rising to move the adjournment, but Madam Speaker, I would like to crave your indulgence to raise an issue that has disturbed me and I think is a grave breach of the decorum of this House. I observed a while ago a member of this House cross the mace and, Madam Speaker, yes, and go walk between the divide whilst the sitting of the House was in session. Wow. And Madam Speaker, this is indeed a breach and a disrespect of this House that we hold quite sacred. The House was in session, Madam Speaker, and Madam Speaker, as leader of the House, I draw this to your attention just mainly because of the fact, Madam Speaker, that this is the Parliament of Trinidad and Tobago, the highest court in the land. This is perceived as one of the most egregious breaches of this House to cross the mace and indeed to cross the Speaker whilst the House is in session. And Madam Speaker, I feel it incumbent on me as the leader of the House to bring this to your attention. Madam Speaker, I am pained by this because it is the first time, I am pained because it is the first time in all my years in the Parliament that I've ever seen that happen. And I think I needed to bring it to your attention before I adjourned the House. I'm not taking it to the privileges, but the House must be respected at all times. And Madam Speaker, I bring this to your attention in my capacity as leader, not just as leader of government business, but as leader of this House. It would be remiss of me if I did not bring that to your attention. So, Madam Speaker, I am bringing that to your attention for your observations to be made on this, Madam Speaker.
So.
Thank you, Madam Speaker. I wish to indicate to you, coming off the tea break, I inadvertently walked down the aisle, and I do apologize. I also had a conversation with the Deputy Marshal of the House, indicating, in retrospection, I realized the error that was committed, and I apologize.
Well, I want to say to you, member for Couva South, whether the leader of the House raised it or not, I intended to raise the issue, particularly because I consider you a member of some seniority and a member who's well familiar with the rules of the standing order and with the decorum which this House required. So I want to say, one, thank you for owning up. And I do recognize the apology. I also want to say to you and to all members of the House that at times we do forget where we are, but that is inexcusable. we all have to, at all times, be mindful of where we are. We have to abide by the standing orders that we, ourselves, it's our contract with each other. It is our contract with our constituents. It's our contract with the wider of Trinidad and Tobago. Yes, it is a very serious breach of decorum, but I think in the spirit in which you have come up and apologized outright, we say yes, we frown on it, but we hope that for all of us, such will not happen again. I thank you. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn to Friday, the 22nd day of February 2019 at 1:30 p.m. Madam Speaker, at that time, we will do an act to amend the Companies Act, and we will start at 1:30. Madam Speaker, I am, though, recalling that there is no Friday the 29th. So in those circumstances, I will ask if the opposition would like to have that as their private members' day. And if they do, I know it is the fourth Friday, but there's no fourth Friday in February. No, it was. So, Madam Speaker, in those circumstances, I'm asking the member for Pointe-a-Pierre in his capacity as leader of the opposition bench, if he would like to have that. Yes, that's what I'm saying. It is the fourth Friday. I stood here and I am now recognizing that Friday the 22nd is the fourth Friday. Oh, I said there's no 29th of February. You were saying that. Madam Speaker, maybe
Just had a conversation with respect to the standing orders and our contract with each other. Excessive crosstalk is one of those provisions of the standing orders that is not allowed. Leader of the House.
Thank you, Madam Speaker. I will repeat. I am recognizing that Friday the 22nd is the fourth Friday. I recognize that whilst I stood. So could I please ask the member for Pointe-a-Pierre what we will be doing on that fourth Friday, which is Private Members' Day? Thank you.
Thank you, Madam Speaker. We will be doing on the fourth Friday, the 22nd of February, which is the fourth Friday, the motion number 1 on private members' business. A continuation of motion number 1 by the Leader of the Opposition.
Honourable members, there is one matter that qualifies to be raised on the motion for the adjournment of the House. I now call upon the member for Caroni Central.
Thank you very much, Madam Speaker. In accordance with the provisions of paragraph 2 and 3 of the Standing Order 16, I raise the matter today, Madam Speaker, of the need for government to ensure that there is a constant and reliable water supply throughout Trinidad and Tobago. Madam Speaker, based on what I am hearing in my own constituency and what I am hearing from constituencies around me, and what I am hearing from constituencies further away from me, I think that we are approaching, if we are not already there, something of a water crisis. Several communities in the constituency of Caroni Central have been experiencing grave difficulty. They do not receive pipe-borne water except sporadically, and truck-borne supplies are few. And this happens in between days, sometimes a week, sometimes more than a week, passing without any water at all being delivered, either through the pipes or with a truck to the homes. These communities include Presal Village, Chickland, Grand Couva, Arena Road, Freeport, Caparo, Ciudas Road, and several other communities. And this happens from time to time. In other parts of the country, Madam Speaker, several communities from Caranage to Toko along the east-west corridor, not every community, but in between along the east-west corridor, most communities in central and south and the deepest part of the southern border, and communities on the north coast as well, have also been under pressure by not receiving a predictable water supply during the period. And this is a period that is especially grave because the Met Office predicts this to be one of the driest seasons of dry seasons ever. I have two documents here which represent complaints that I've had for the last 3 weeks in my own constituency. And I want to draw on the January 10, 2019 media release of the Met Office in which they made the assessment of the criteria necessary for the onset of the dry season, showing that conditions have been met and are now entrenched. And they basically indicate that it is a combination of reasons for this, one of them being climate change, but the other homegrown reason really is the management of the flow of water within the available supply in Trinidad and Tobago. Madam Speaker, one day after that 10th January report, media released by the Met Office, the Minister of Public Utilities indicated to citizens that there were plans in place to deal with the dry season. And basically, that was an assurance that things would not turn out to be bleak. And although the dry season might be harsh, we would have water, because in addition to that, both from the Met Office and from WASA and from the ministry, we got warnings that we should conserve water, we should try and manage it, etc. But if you don't get water in your taps, and if you don't get any pipe-borne water, then there is nothing to manage or conserve. And this is the situation in which many of the citizens of this country find themselves, Madam Speaker. And we also had editorials, one from The Guardian and one from The Express. The Guardian is on the date 2/11/2019, and the Express editorial is on January 4th, 2019. And they speak of these perennial water woes and the difficulty of communities. In the Guardian editorial, many of the communities are in fact mentioned having these difficulties with water and with suffering, without water and with suffering. Now, Madam Speaker, I raised a question on this matter on the last sitting of Parliament, not today. And I asked it to the Prime Minister at that time. The acting Prime Minister answered, but I wasn't satisfied with the answer. And because question time ended when he gave his first answer, I could not follow up with any of the issues. And as I said, I found the answer unsatisfactory, and I hope the minister who is present will in fact give some answers of what is to be done to bring relief to the citizens in the communities which exist in my constituency, but also all of these communities, because water is an essential ingredient. You can't live without it. You can't function without it. And it really causes a tremendous hardship when you do not have it. And the unpredictability of it is perhaps the hardest kick of all. Now, Madam Speaker, I want to raise this in a context in which, you know, in 2010, there was an 18% reach of pipeborne water to the population. By 2014, under the then minister, the member for Chaguanas West, we had gotten to the point where we had achieved a 73% reach. How did that happen? That ministry at that time, up to 2014, early 2015, laid out about 1,000 kilometers of pipeline. That exists now. They added 18.4 million gallons of water to the pool. And that was per day to the pool, potable water. So they added that to the distribution system. And they did that on the basis of the way they manage desalination water and on the way they also manage ground and surface water sources. Now, at that time, they did an assessment, and they assessed that what we needed in Trinidad and Tobago, which is a high consumption country for water compared to other countries, and we do need to conserve, so I support the minister in the whole call for conservation, is that we needed we needed about 270-something million gallons of water per day, but we actually had about 241.8. So we had a deficit of 17.2 million gallons per day, which means that for all intent and purposes, notwithstanding that you had improvements, water still had to be managed. So my question to the Honorable Minister is, what have you done? And what can you do to relieve the situation? There must be some things that you've done to build on what was our legacy, or build on what we were able to contribute. And there must be some things that you must be considering now to bring relief to the ordinary people. And Minister, you would appreciate that this seems like a simple matter when you talk about water. It sounds like an everyday affair, but to people whose lives have been disrupted by lack of water, it is not an everyday affair. It is really a stressful thing. And if you have children compounded in this situation, if you have to go to work, if you have chores to do, etc., it is a very unhappy thing. You and I know if you don't get water for 2 or 3 days, you're like a fish out of water, literally. All right? It's very, very hard in your home because you are accustomed to that as part of your comfort. So the question I ask is, what have you done so that what have you done that we are in this situation now? And secondly, what can you do, or what are you willing to do to make it better? Now, there are things that can be done, and they were identified in the manifesto that we did in 2015, that we needed to have new sources of water supply, that we had to reduce demand, so I support you on that.
Central, your speaking time is now spent.
Okay.
Minister of Public Utilities.
So I leave the questions.
I would like to start, Madam Speaker, by stating emphatically that this government wants to ensure that there's a constant and reliable water supply to the people of Trinidad and Tobago, and that we are working towards the realization of that vision. We are doing this despite the fact that this goal has evaded Trinidad and Tobago since our birth as a nation, and despite the grandstanding and glib statements that are often made by political mileage, like water for all. Let me also state that the figures are said before. both the starting figure and the ending figure. I like to put on records that I disagree with those figures. Madam Speaker, everyone stands up and say that we are fixing the water supply problem without strategically and systematically taking the steps that are needed to do so. I remember saying in my maiden address in the Senate, Madam Speaker, that fixing WASA was like fixing an aeroplane while it's in the air, and that it requires a multi-pronged strategy implemented over a period of time. I stand by that analogy, Madam Speaker, and I will share with you what we have been doing to fix the aeroplane while piloting it. Madam Speaker, we are not a water-scarce country. The truth is that during the dry season, we produce on average about 217 million gallons of water, and during the wet season, we produce about 243 million gallons of imperial gallons of water per day. This is more than enough for a population of 1.4 million people. Despite our relatively high level of water production, we are faced with some challenges in the area of transmission, distribution, storage, and demand management. And the end result is that during the wet season, only 60% of the population gets water 24/7, and during the dry season, that figure drops to 31%. That is the reality that we face, and it is one that will become even more acute in the harsher than usual dry season that we have upon us. Of course, Madam Speaker, we find ourselves in this distressing situation because when the national coffers were full and we had money to invest in WASA, it was not done efficiently and effectively. Madam Speaker, over the period 2010 to 2015, almost $14 billion was spent on WASA to cover operational and capital investments. The critical question that we must ask is whether the people of Trinidad and Tobago receive value for that money. I would like to use 3 examples, Madam Speaker, that will illustrate just how that money was used. The first involved the fact that during that time, 41 kilometers of 24-inch pipe were installed at a cost of $4.8 million per kilometer. Currently, Madam Speaker, we are installing the same 24-inch pipe at a cost of $2.1 million per kilometer, half the price that was previously used. What that means is that for the same financial investment, we are doubling the impact. Put another way, if we had the same amount of money, we would have been able to do not 41 kilometers, but 82 kilometers of pipe. Then there is, of course, the infamous $1.6 billion Beetham Water Recycling Project that was awarded to Super Industry Services Limited. To date, over $1 billion was spent, and not one drop of water was produced. The third example, Madam Speaker, involves the 12-month action plan that was developed. Yes, it was there. To date, many of the projects have not been completed, although all of the money that was earmarked for it had been spent. And a number of contractors are still calling on WASA to pay outstanding debts. As I said before, years of mismanagement aside, our shortfall in water supply as it currently exists is worsened by what is now called drought conditions. Madam Speaker, the fact of the matter is that the current water levels at some of our reservoirs are as much as 20% below the average period for at this time. In Trinidad and Tobago, 60% of our water supply comes from surface water. When this is coupled with the fact that our reservoirs can lose as much as 190 million gallons of water to evaporation during the dry season, we realize we must find a way to effectively manage this crisis. And we are doing just that. I will go into some of the strategies that we are implemented, but I would like to make it clear that beside those initiatives which have a national scope, we are also dealing with the water supply problem at the regional level because we understand that each region is influenced by unique factors. Caroni South, for example, Caroni Central, for example, is supplied by the Caroni Water Treatment Plant, the Carson Field Water Treatment Plant, the Freeport Water Treatment Plant, together with a number of wells. During the dry season, the Caroni Water Treatment Plant has reduced its production to the South region by 15 million gallons per day, which has resulted in these areas now being placed on a scheduled supply. Some of the wells supplied in the areas also need rehabilitation. And while the rehabilitation of the wells can be addressed and are being addressed, the reduction of water supply from the Caroni Water Treatment Plant is required to conserve water during this dry season. And it cannot be and could only be augmented by truck-borne delivery, which we are attempting to do. Madam Speaker, now that we have fully grasped our current position and the reasons behind it, I will spend a little time giving an idea of what it is that is planned in the future. I am on record as saying that state enterprises are established primarily to provide a service, not only to provide a service for the people and just the creating of the jobs. And therefore, efficiency must be one of the core principles that govern their operations. Madam Speaker, I am happy to say that we have already made gains in this area by dramatically cutting the number of contractors that WASA hire and by allowing the WASA employees to do the work that they are paid to do. In terms of the production of water, we are currently drilling 15 wells throughout the country in North, South, Chatham, Chaguaramas, Maraval, Santa Cruz, Tobago. 2 of these projects are scheduled to be completed by March of this year. Together, they will add 500,000 imperial gallons of water to the system today. When all 15 wells are operational, they will add an additional 3.5 million gallons of water to Trinidad distribution system and 4 million gallons in Tobago. We are also rehabilitating the existing wells. Of the 27 that were earmarked for rehabilitation, 21 have been completed, and the remaining 6 will be completed by the end of next month. In terms of storage, despite the billions of dollars that were spent in various years, we are only approximately 5% of international standards, 13,000 gallons per capita versus 400,000 gallons per capita in international storage. And so we'll be expanding our storage capacity across Trinidad and Tobago. One of the major projects in this regard will be the desilting of the Hillsborough Dam in Tobago that is due for a very long time. We are all aware, Madam Speaker, that the infrastructure is aged, which results in leaks throughout the network. We have identified close to 150 kilometers of pipe that are in immediate need of replacement, and we are moving expeditiously to have those replaced. Over the past year, we have brought a number of reported leaks down, and we are working on that. Madam Speaker, the reality is we also have a lot of problems with regard to water demand management, and because of the level of water demand that is being used and the excess amount, I have yet to find in my research where you have 24/7 water with this level of water demand. The fact is, Madam Speaker, the vision for 24/7 water is within reach. The promised land is close at hand. With deliberate focus and astute management and leadership, it is possible. Madam Speaker, I thank you for your time and attention.
Honorable members, the question is that this House do now adjourn. All in favor say aye. Aye. Any against? The ayes have it. In accordance with Standing Orders 11 and 12.1, this House now stands adjourned to Friday, 22nd February 2019 at 1:30 p.m.